Hello, everybody, and welcome to 2025. It's the first of my live stream sessions, and I'm sorry I missed. Last week's was January, wasn't it? Your one, Mike. It was. I wasn't able to make that, so here we go again. And I haven't got a great deal of news, and I'm thinking this will just be. I'm still sort of struggling to get my energy level back to what it was in December. I don't know about you guys, but it feels like it's 3 times harder to do things now that I had a break. So I was, part of me was saying I don't think I can go ahead with the live stream tonight, but I thought I'd got to do it. So thank you all for turning up, and I'm just going to check the comments section just in case there's anybody leaving comments. I think I can see them here. Oh yeah, unless these are from last week. We got 2 comments already. Yes, I think this might be one. So has anyone got anything you'd like to say before I put any comments up?
No, I'm all good. I'm just digging out a video, an LGO decision that's going to relate to that question in the chat. So just bear with me, and I'll try and get it into the chat as well.
I'm just conscious, Mike, your audio is a little bit quiet. Is there any way you can? Are you speaking onto a mic on the headphones? No, that's gone.
Now?
Yeah, that's better.
Yeah, you know, but I'll figure it out.
Okay, great. So I'll put the first comment up if it works. Yes, it does. This is one of 2. So this is from Vince. Hello, Vince. It says, what's the procedure to be reimbursed by the council for the court's costs and for bailiff's costs? A friend is in priority need. The council told him to stay until the bailiffs stay until the bailiffs. Only after the final eviction, the council can provide interim accommodation while waiting a final decision. So I think what they basically said, I think that what you're saying there, Vince, is that your friend got told, wait till you're actually evicted and then come down. And as a result, incurred the costs of the possession proceedings and ordered that they pay the landlord's costs and the bailiff's costs as well. And I should add to that, before I go into answering that, I don't know if any of you have watched on YouTube. I don't know why I was watching it, but I think it was because I was sitting in an airport and I was watching those programmes on YouTube, the ones about the bailiffs, the High Court bailiffs that come, and they do 2 things. One is they're recovering money to pay debts, but they're also doing High Court bailiff evictions. And I realised most of these videos were from about 2012, so they're quite old. But the worst thing about it was, and it's changed since then, that I don't know if everyone's familiar, but there's 2 different sorts of bailiffs, or at least 2. There's the county court bailiffs, which I tend to think of as the sort of laid-back bailiffs, who may be retired police officers or something. But then you've got the hardcore people in the High Court, who are originally, they're also known as sheriff's officers, which does go back to the olden times. But they don't mess about. If they say you're going to go today, then they're not leaving until you've gone, and they'll break the door down. But they kept, and back in 2012, there was no requirement for the High Court bailiffs to give you notice that they were coming, believe it or not. The landlord would issue a warrant. The landlord would ask them to issue a warrant. They'd issue it in the High Court, send them a message over to the sheriff's officers, and this would normally be really quick, like within a matter of days, and then they'd just turn up at your front door. And they kept getting told the same thing by people in there. They'd say, why are you here? I was expecting notice of an eviction because the council told me to wait until I'd got the bailiff's notice and then come down. And so I was waiting for that. And the bailiffs, the sheriff's officers were actually pretty nice people. And there was a couple of times when they were faced with people with children and they wouldn't evict them, even though their rules said they would. It was like Friday night or something. but they had to ring the council, and it showed them trying to get through to the homeless persons unit. And this is 10, 12 years ago, so things have got a lot worse since. But the good news is the county court bailiffs, the high court bailiffs now have to give notice. The law's changed. But even so, it's a big worry. And to go back to Vince's question, the procedure, I think I'd have to say there isn't one for recovering costs from the council, unfortunately, because if you ask the council to repay you, they would almost certainly say we don't have to do that. And you wouldn't be able to take legal action against them because legally it's the duty that the council have to house you is a public law duty. It doesn't give rise to private rights, and you only claim compensation except in rare cases where you have a private right. So if I make a contract, if I sell you a burger and you get food poisoning, you've got a private contract with me, and you can sue me for whatever. Or even if I run you over in my car, that's a private duty because I've got a duty of care to avoid crashing into you. But if you go to the council, they don't have a private duty towards you. They've just got a general public duty towards the public in general. So we've talked about this before, I think, where we've talked about people that get put in horrible accommodation, and the courts have really rejected almost all compensation claims. The only exception is where it's a breach of your Article 3 human rights, and that does give rise to compensation, but it's got to be pretty severe or phrased in a particular way. So, but what I think we've talked about before is that you could make a formal complaint, and that's probably the closest there is to a procedure, although it's by no means, there's not a procedure in the sense that they'll say, oh, you're claiming compensation, you've come to the right place, fill in this form and we'll give you your court costs. What you'd probably have to do is write to the council, make a formal complaint. They'll say, no, you're not having anything, and then you complain to the ombudsman, and you might then, and maybe Mike and Shannon, you can help, and Karis as well, sorry, but you guys do more ombudsman stuff than me. But it's probable that you might get some extra compensation for not having been housed, given temporary accommodation when you should have been, and then you went through the distress of the court proceedings as well. So it's not just the money that you'd have. The other thing to bear in mind as well, though, is that when you get taken to court by a landlord for possession, it's quite likely that they may sometimes get an order saying costs summarily assessed at £500, but often they'll say the tenant to pay the landlord's costs, and it doesn't say how much they are, and that's probably the last you'll ever hear of it, because the landlord isn't going to chase you for the costs, partly because they don't know where you are, and it's just what's called throwing good money after bad to try and recover the costs. But if you could show that you'd had to pay out money, then you could make a complaint. And again, you could make a complaint anyway and try and get compensation for the distress. So Vince, your friend, could hopefully do that. If they go to the council's website, they'll hopefully find a link to the right place or the address, and then start the ball rolling there. And if you don't get any joy through the internal complaints procedure, go to the ombudsman and make a complaint. Anybody want to add anything to that?
Yeah, I've just put two LGO decisions into the chat. There's only two I could find. I've been on the LGO website to see if there's more like this. But in that, in the Islington case, that was where the tenant claimed, or basically complained, and got compensation, and they got £355 as an element of it. They got like eight grand in total, but it says specifically £355 was specifically to have covered the avoidable court costs. And there's the Brentwood one I put in there as well, was where a landlord did the same thing. So the landlord got compensation because the council had told his tenant to stay put. So in that case,
Mike, could you paste the link into the YouTube? Is there any chance I can't see the? Hang on, maybe I can see it here. Hang on, maybe.
Check. Yeah, check.
So often YouTube deletes the links. So whenever I do it on the HBP channel, it will delete the link. So it might be worth popping
Okay.
it maybe in the Zoom chat, Mike, and then Will can put
Yeah.
it.
So I'm just looking
Yeah.
Because you
for
can
a
put it
page.
if it's your own channel, but if it's someone else commenting a link, I think it just assumes it's spam.
Okay.
Oh,
Yeah.
hang
Hold
on,
on.
hang
So
on. I
here's
can do it like this. I
first one,
think
Will.
this is how I'll do it. Oh yeah, there we go. Hang on.
Yeah. So that, and then. Yeah, so one's Brentwood, one's Islington. As I say, I've been through that because I assume this would be fairly common. The law is pretty simple on this, that council shouldn't do it, but it's surprising how, it seems to be fairly rare that anyone actually takes it out with the ombudsman and gets money back. So, for the landlord one, he got something like £1,200 in total. The Islington's one interesting for another reason because it's not usually you get like £8,000 worth of compensation. But as I say, part of it was so another £250 was in recognition of the unnecessary uncertainty and anxiety caused effectively by telling them to hang on until the bailiff came. So plus this £500 a month for every month she was in past the date she should have been. So yeah, it's kind of the £7,000 element is unusual, but the rest of it should be pretty much bread and butter. So yeah.
So how much?
it's
Sorry,
worth- definitely
how
worth
much did they
complaining.
get?
Well, so the Islington one, the tenant got 355 to cover the avoidable court costs, 250 for the unnecessary uncertainty and anxiety, and then £7,000 because they've basically been left in. I need to read it again. Basically,
Yeah, me too.
They've been left in 14 months in the tenancy past when they should have been, and I assume there was massive court delays or something. But yeah, and basically, and then £500 for every further month that they're in the tenancy before the council actually offer interim accommodation. So as I say, there's well worth complaining.
Yeah.
But as you say, like the council's first and second stage response will say, no, we're not paying anything until you kind of either take it to the ombudsman or threaten to. That's when they actually might kick in and be actually more reasonable.
So Vince, I hope that answers your question, and just go through these other ones. Cheeseface, hello and good evening to you too. Happy New Year. And then we got a question from Anthony Dalton here. Hi, what is higher out of the two, lawful or legal? I struggle to understand council's policies because of this. Thank you. Does that relate to an earlier question that because lawful and legal are two sort of words that do confuse, even lawyers get confused by it. What's the difference between something being lawful and being legal? Is if we're missing the question,
I think that's what he's asking. Yeah, no, I think that's what he's saying. It's just basically saying is there a difference between illegal and unlawful?
Sorry, I've got some people shouting in the background, so I missed that. So, does anyone want to have a stab at answering that question? I was rambling on the last one, so
I can have a quick go. Well, go on, Karis, do you want to go?
No, go for it.
So my understanding is there's no difference at all. It's just used interchangeably, and in certain acts, it's even within the same paragraph. It will just use the two terms interchangeably. I think just illegal sounds a bit more like, I don't know, gripping. You know, if you're going to say that council's acting illegally or the council's acting unlawfully, illegal sounds a bit worse. But they're doing the same thing. That's my understanding.
I think illegal means incurring criminal liability. Because if you say I was illegally fly tipping, or well, I suppose all fly tipping's illegal, but you know what I mean, an illegal rave or something like that, those are things where the police might turn up if you're doing it. Whereas if it's unlawful, if I do a negative, if I find somebody who's clearly in priority need not to be in priority need, that's unlawful. But I think, strictly speaking, it isn't illegal. Nobody's going to arrest me for. Well, unfortunately, nobody's going to arrest me for it. But council's policies. I mean, if they say that something's illegal, I'd be surprised if they do that. I think they probably wouldn't even say unlawful because they don't want to encourage people to think that they do things wrong. Because most council policies are based on the idea that the council, what they'd ideally be doing, rather than saying occasionally we'll screw up.
Yeah. And I would say there's a kind of like a subtle difference between lawful and legal. And lawful, it's kind of encompassing the intent of what the law is and complying with and more ethical and moral. grounds, if that makes sense. And legal is kind of more technical, legal. If you're using the wording in what's written, specific statutes, rules and regulations, unlawful just encompasses everything. Is the only slight difference, I'd say, but yeah, they're mostly interchangeable.
I just Googled it because I cheated, and I don't know this myself. Because I always thought they were just interchangeable and one sounds worse than the other. But yeah, I think, Karis, that's quite a useful thing about the context stuff. So it's saying like unlawful is an action that's not allowed by law, but there's no specific sort of niche law that prohibits it. Whereas illegal is something that breaks a specific law or statute. So like, actually illegal is sort of, worse, I guess. Because it's more specific. But I don't know if it is worse, because unlawful, it's almost more dodgy because they're utilising that grey area to worse. So I take that back, actually. I don't know what is worse, but different.
It's only kind of little bit, I'd say, was just how it's used in context.
So I just I put like I don't know if you can share this one, Will. So I just put a link. So there's a really cool channel called The Art of Law, which is a barrister guy. I don't know if he's retired or not, called Alan Robertshaw. But he did a video about this, and he gave some example from statute where within that, I can't remember which, it's linked in the actual video, but it's kind of saying even within law it will kind of use the two terms to mean the same thing. So yeah, it's a good channel to watch. He does cover some interesting stuff around libel law as well, which is interesting.
Yeah, I've watched that channel. It's pretty good. Although I got a shock. You know that what's his name? The guy who was a stalker who went to prison for stalking. He was stalking Jeremy Vine. Do you remember what's his name? Alex? Belfield.
Yeah.
And that guy was his lawyer. Was his barrister in court, or represented him at some point. I think. I'm sorry. I apologise if I'm wrong about that, and you weren't. But I would really love to hear him talk. I suppose he can't talk about that case because he was directly involved. But he's a very interesting guy, and he manages. He's got a lot of. He shows us, I think, a possibility for future viewing figures because he's got a lot of followers. But he manages to make legal issues really interesting for the public generally.
He'll like get a news story and then say, what's the law? So he did one this week about can Jess Phillips sue Elon Musk? So stuff like that. But he did a really cool one about the fact that local authorities can't sue you for libel. So individual councillors can, or individual officers can, but a council can't sue you for libel. So I was kind of paying attention to that, thinking, okay, how do I not get in trouble if I'm saying that councils are breaking the law all the time? But yes, there's some good videos on there about all sorts of things. Actually, he used to be like a libel lawyer for a newspaper, so they kind of put it to him and say, "Can we say this? Can we?" Yeah, and he'll often say, "No, you can't." But yeah, he's quite an interesting guy.
Yeah. So I think that's all the questions on the comments for now. So Karis, over to you. You were saying that you wanted to. Or you were interested in talking about homelessness and winter. It's quite topical because it's pretty cold out. Well, in London, it's pretty freezing outside. But do you want to say a bit about that? I'll start off. Oh, I think
Sorry,
you're muted
just
actually.
unmute myself.
Oh, there you go.
Yeah, I can do. I was volunteering you, but
Oh, you were volunteering. You were. Oh, right. Thank you.
I was going to say for street homelessness, in terms of we're coming to the lower winter temperatures, and kind of, and not a lot of people know this, and it's not quite widely known that local authorities and local government have the severe weather emergency protocol. It's just an topic right now because it's we're currently in snow, minus temperatures going into minus 3, 4, 5, -9 in some parts of the country, and it's snowing, and it's wet and mushy, and there's ice on the road. So it's just kind of giving everyone what the severe weather emergency protocol is, which is the local authorities have to provide night shelters. They're often done on a first come first served basis, and they don't charge for a bed. They're not allowed to charge or anything. It's not about a housing benefit. You don't have to apply. But it'll vary from local authority to local authority, but they're supposed to do direct access to hostels, and refugees access to emergency accommodation and supporting those fleeing domestic abuse. It's available for them. What your rights are in terms of providing a place to wash, especially changing your. I think there's something about changing your shoes and providing warm clothing and food in the severe temperatures. And that's supposed to be immediate. It's called immediate relief. And what but each local authority should have something on their website. But obviously, for street homeless, you might not have access to that. But it's also about the local authority working with StreetLink. I think they're supposed to. It's not
So
universal.
are you referring to a particular law, or you said a protocol? But is there an act of parliament or something that says when it gets to a certain temperature you have to activate this? Sorry, Shannon, I didn't mean to cut you off.
No. This is what I was going to ask, because I was under the impression, and I could be wrong, but like I was under the impression that sweat isn't. It's not something the council has to do. Like it's not a legal duty, which is why it varies so massively between town to town. Like I know some towns will do it if it gets like under 3 degrees. Some towns it'll be under 0 degrees for more than 2 nights, or 3 nights in a row for 2 degrees, or like there's all these different like rules. Some local authorities, like Bedford is just open till March now. But I didn't think there was any legal duties to do it, because otherwise like they wouldn't be able to kick people out and have that sort of like, and that's often quite a common thing that I think happens in sort of night shelter settings. And it would mean that most across the area, like I know we get postcode lottery anyway with legal homelessness stuff, but it's particularly rampant, I feel, with sweat. But I could be wrong, sorry, Karis.
No, it's whether it should be, it's like a trigger, and I think they're encouraged to do it, but I don't know whether they have.
There's a section, I'm trying to find which section it is. It basically allows the council, basically there's one of the sections of part 7 is it allows council to do certain things, and so then you've got the government good guidance, and I don't know if it's changed over time, but it used to be that it would be triggered if it was freezing for 3 nights in a row. It's forecast to be freezing 3 nights in a row, but then Shannon says different local authorities do it in very different ways. Some local authorities use hotels. They'll pay for people to go into hotels rather than like run like a night shelter type thing. In Bedford, it's just basically a bunch of camp beds in a big hall, and they're kind of saying that it looks amazing, and I don't know, I couldn't think of anything worse, to be honest, but yeah, I could, but you know what I mean?
Yes, I wouldn't. Yeah, again, so it's not a legal act like the Homelessness Act. It's not Rough Sleepers Act. There's nothing universally legal requirement, but it's good practice to do, and it's in place when a common trigger, but each council will be different, is when it hits 0 or consecutively below in 3 nights. But I think and this may not be quote me, but it's the Homelessness Reduction Act put a general duty on councils.
I've put a
I'll
link
double-check
to the
that.
shelter website on that, which does have a page. I'm sorry that hopefully you can click on that on the actual YouTube link, but the
There's
there
more,
was some more
they
stuff
say
there.
ethical implication, and it's up to each local authority to decide how and when they implement what they're to do. But basically, what they're supposed to do is have a place where you can get warm, immediate relief from wet food. And it's wet food, wet clothing, so change. But I remember one person trying just to get them showered was really complicated in the end, and it was really hard. But sometimes they're all quite good, and they'll have a whole bed, food and coffee waiting for people.
And I guess it's probably worth, obviously, like, if someone's gone to the council, say they don't have Google and they've just gone to the council and the council's gone, here's, and, you know, they've gone, look, I'm homeless, I'm sleeping, it's freezing, where can I go? Like, what can I do? And if they say, well, here's sweat, then they've also probably gatekept you because you've just made a homeless application. And, like, I feel like I'm just pooping on sweat, but it really annoys me because I'm like, we just care when it's freezing outside, and that's when
Yeah.
our moral obligations kick in. And I know it's like, I'm not saying we shouldn't have SWEP, that's not what I'm saying, but like, I do wonder if the law was just followed, would we even need SWEP? And again, I'm aware that it's potentially particularly helpful for people with no recourse to public funds, or people who may be found intentionally homeless or whatever, but then the council could use that moral argument to have
Way
their powers.
before
like,
any of this
they
needs to
could-
be in place. Yeah.
Exactly. The local authority still has powers to accommodate people in TA, even if there's no legal duty, right? So, like, it's just a really weird concept to me. But it is, like you say, it could save someone's life, couldn't it? So,
Yeah, especially because was quite surprised how not a lot of people know it's supposed to be, and probably even some people that work for the local authority didn't know it exists. And it's absolutely horrendous that we need it to be in place. It shouldn't even be a measure. They should have, and like I say, when you walk in the door, shouldn't that be an automatically someone going, okay, where did you come from? You know, why are you here? Why do you need this place? There should be someone stationed at the door, not as a doorman, but asking relevant questions so they're not in that place in the first place. Definitely.
It's often advertised on local like Facebook groups and stuff as well. So if you kind of, you're not familiar with your local services, if you go on like your We Are Bedford website, or Facebook group, they'll sometimes share stuff around it. And so a lot of areas have their own specific homelessness page. So if you search for, so they like Southend, when I see quite lots of Southend's got like a couple of Facebook pages. So if you go on there, they probably share it around as well. So, and day centres and stuff like that would also probably get a heads up that it's opening. So and kind of tell you where to go and all that sort of thing.
I was just thinking, while on the subject, I mean, if it gets really cold, then it changes the nature of vulnerability, doesn't it? Really, but because vulnerability at the moment is based on the assumption that the weather in Britain is fairly temperate. Because if you lived in Kazakhstan, everyone would be vulnerable because homelessness is going to kill you if you're outdoors in the winter for more than half an hour or something. I watched one of those programs about the coldest places on earth, and like, it's a serious problem if the school bus breaks down, because they've got about 30 minutes to get somewhere warm before it becomes fatal. So, but the problem, I suppose, in this country is that by the time, if you challenged them and they said, "Oh, we think you're okay, you're not going to suffer any harm or injury," I suppose they'd say, "Well, the fictional able-bodied person would also suffer the same things." But I think you'd be less able to cope with the effects of homelessness because of the cold. But I'm sorry, I'm sort of following a thought there, but I haven't really crystallised it.
no, so do you think it'd be enough then do you think it would count as fresh information to trigger relevant information to trigger a fresh application when the decision was based on someone's priority need?
Yes, although the problem I'm having is that, number one, by the time you actually got the thing into court, if they said no, the weather would probably have improved again. So they would say, well, it's academic now. But it might mean that they should have processed if they'd said, no, we're not going to process your application, I suppose you could do. But again, the problem is it would be quickly out of date. So I don't think it would make that much difference, and I guess in practice it doesn't get cold here for long enough at a time for that to be tested.
I guess like the bonus of people caring more in winter and when it's cold and stuff is at least potentially if you go to your MP or the papers or on Facebook or whatever, there might be more of an outrage when it's snowing outside or chucking it down with rain and stuff. You might get more helpful responses from like MPs and whoever else.
Well, you got this during coronavirus at the beginning. The government was faced with a problem in that they, for the last, 2020 coronavirus started. So for at least 10 years before that, they've been trying to make life as hard as they could for people who didn't have recourse to public funds and were not considered to be welcome. Or what was the something environment, wasn't it? Hostile environment. But the problem so whilst they could score some points with the sort of some meat for the trolls by being horrible to people like that most of the time, they then were worried that the government would look really bad if there were people dying of coronavirus in the street because they couldn't get accommodation. And then they were faced with the legal thing of, oh dear, what do we do? Because we've spent 10 years making it impossible for people to get housed. So now how do we say, oh, well, actually, we were only kidding. Here's a place. And they had to, I think these sorts of powers and protocols were sort of explored to say that you've got these residual powers. All along they could have housed them, but they did, and it's all died away again now, hasn't it? So if it's okay, I'll move on from. Oh, I've got some comments. I've got. Sorry, Cheeseface. I didn't. I got a couple of comments from you. Going back to the lawyers online. There's the black belt barrister. I don't know if anyone's watched him. I'm not as big a fan of him as I am of the Art of Law guy, partly because he talks in a rather melodramatic voice, and I think that can't be his real way of speaking. But
he hates Meghan as well. Everything's like he just hated Meghan.
yeah.
No matter what the issue is, Meghan's at fault. So she's done something.
Yeah, and I'll go on the record as saying I have a soft spot for Meghan Markle, and I think she's been very badly treated. But I won't digress further than that. But so yeah, I don't like people that go on YouTube slagging her off. Cheeseface, do you think if you can each done a night out, it would give you a different perspective? It would be cool to do a homeless application and cover the process. Can't think of a way to do it without being a real application. Is that addressed to us, or Cheeseface, or is it just people generally? If they slept rough, they might have a different perspective.
I think part of it's just
Or us
talking
going
about
undercover.
journalism.
So is that?
Yeah,
what you
I
mean?
think it's about undercover, like because I've seen a few documentaries that have done it. They did a terrible job. I think Dispatches did it like 10 years ago, and they went in, they kind of filmed. I think they got people who've been homeless to go in there, but they weren't homeless at that point. So you could argue that they were kind of giving false information to try and get housed. I think that's what the concern would be. And then basically, yeah, this one individual in particular got badly gatekept, and then the documentary didn't really mention it. They're like, oh, could have been better. It's like, no, well, there's broke the law and left the homeless. So I think that's kind of something that's occurred to me a lot. Is kind of, I think, if there was like a really kind of well coordinated undercover, kind of secret shopper type thing, you'd be able to kind of get very easy evidence of just kind of how kind of bad it can be, in a way that you can't really articulate it how it is to be in those interview rooms, like any other way. I don't think.
But local authorities are pretty nasty about using this sort of criminal offence business to. You were talking, Mike, weren't you, about a case where somebody had been gate kept, and the response of the council was to get them in a room and sort of read them the riot act about, do you realise that if you're giving false information, they're making out it was like sort of a mandatory prison sentence or something a lot of the time. But I think watching those bailiff videos, I think will give people a different perspective, because you see these, you do see them ringing up the council and having to hide. They edit it so they don't show how long the bailiffs were holding for to get through. And again, it's misleading because it's 12 years ago and things have really got a lot worse since, because that was just at the beginning of the austerity period. But now, it would be quite an achievement to get through to somebody, but maybe the bailiffs have connections, I don't know. So another one from Anthony here. A person was provided with a letter from a psychiatrist stating that they were in full support of the person remaining in the borough they were in, but the council ignored that. What can the person do next? Anyone want to have a go at that one?
It's quite a tough one, actually. So, I'm going to have to refresh my memory from the last week or so, because there was something about like medical evidence being ignored. I would say that the council would need to give a rationale for why they're going to disregard the psychiatrist's opinion. But I think the annoying thing is if they kind of did that, if they paid lip service to it, they could probably get away with sidestepping it and just saying, there's no. In fact, it was an LGO report I read for Leicester, And basically, in this situation, the kind of case was this amazing OT by the sound of it. She had basically ended up making a complaint to Leicester Council and getting them compensation, but she had regularly or consistently cited that there were safeguarding concerns with this disabled child being in a particular house because the parents were having to carry this child up and down the stairs. There was risk of falling over and stuff, and so there was very clear evidence of there being a real concern. And it ended up getting upheld on that point because the council hadn't properly considered the OT, and there was no reason that the OT was kind of like wasn't telling the truth. I can probably dig out the case actually in a moment, but yeah, I think it was a good example there of councils ignoring medical evidence and how it can kind of come about, because there were quite a few elements of that case which weren't upheld because and effectively the council's excuse was, we haven't got any accessible housing for this family, which I don't think is a legitimate excuse, but the LGO seemed to kind of accept it. But yeah, basically on that particular point about the issue of a trained OT who was working within their remit, as a psychiatrist would be potentially to kind of work within their remit, I think there was certainly some weight to it. But I got the sense that if the council would just kind of were clever how they'd responded to it, or they could probably got away with kind of doing whatever they want, really, as long as they provide a rationale that's not so perverse, it's kind of nonsense, they might be able to kind of do it that way. I'll try and dig out the link to the case, because it might be something that's worth reading for that person. But that's my answer anyway. I don't know. It's not a very encouraging one. But I think certainly what the council can't do is ignore it or just kind of gloss over it in their decision-making process. They need to make sure that they can evidence that that offer of accommodation is going to be suitable wherever it happens to be.
Right. Yeah. So I would just add, ask for a written explanation of why they're not considering the health report, the psychiatric support, and then you can put in a complaint, or you can ask to review the decision. So.
Yeah. I mean, I would just add that a psychiatrist stating that they're in full support of somebody doing something wouldn't necessarily make the council have to comply with that unless the reasons for that. Because if the person, usually they say, I don't want to go out the borough because I have a support network, including medical support in the area. And the council's response is, well, the NHS is a national organisation, so you can get that support elsewhere. And if the psychiatrist is, forgive me, I don't mean to be unkind about psychiatrists, but sometimes doctors and people can be a little bit hello, I'm a doctor and I like to endorse this person. Or they don't give any reasons for it. And particularly a consultant psychiatrist may be used to people sort of saluting if they say something. So the psychiatrist simply saying they're in full support is great. I'm in full support of various things, but that doesn't mean that they're going to happen. And that's what a hard-nosed council could say, I think. But if the psychiatrist said, I believe they need to stay here because, for instance, they've got a condition which would be severely deteriorate if they went to a different area and had to start with a therapy all over again and build a relationship, I would think that would be a major factor, and it would be an unlawful decision if it was ignored. And Anthony's added a bit more to this, which says the council leader ignored it. Can the person go higher? Well, I think we all know a place where you can go if you're not happy with the council's decision, apart from a judge, which again would be a complaint to the ombudsman, I think. Again, I'm surprised it would be the council leader doing that, but maybe you mean the person at the top of the pyramid within the council, because definitely complain to the ombudsman or consider a legal challenge if there's more to it. But again, if it was just they didn't listen to my psychiatrist said they supported me, and that wasn't enough, and the judge, even the ombudsman might say, well, they did consider it and said, there's no maladministration there. So I'm sorry if I sound cynical. It's just I've seen this sort of thing happen, because doctors will often write letters saying this person says they're really ill, please house them. and you think no, that's you've got to diagnose them and give some reason. So, and the councils are, as I say, pretty hard nosed. So, in the absence of any more questions, can we got, unless you guys want to get away, we've got 20 minutes. Can I just start the ball rolling with a discussion about lodgers' rights? Because somebody presented me, I can outline the issues without breaking confidence, but somebody contacted me about a problem they had, that they actually have a lodger and they wanted to get rid of them because they were misbehaving, and they wanted to know whether they would be liable for unlawful eviction if they evicted them, and also what had happened was they changed the locks or made the lodger leave or prevented the lodger from getting back in, and the police actually sort of came round and said, you've got to I think the lodger got arrested, and the police brought the lodger back and said, you've got to let him back in, which is odd because the police are usually very good at doing the opposite and saying to tenants, no, we can't get involved. It's a civil matter, and so it raised a number of issues. And again, I mean, most people listening to this are probably more likely to be lodgers or have sympathy with lodgers rather than the people staying with them. But it comes down to whether you let someone stay in your home. I mean, we're calling that a lodger and they pay you a rent, but it's a very common problem that people have somebody sleeping on their sofa and then it's difficult to get rid of them, and the legal position is worrying because you might get the council ringing you up and saying, you do realise you've got to give them notice and take them to court, because they don't want to rehouse the person either. And so I'll just summarise it because I looked it up, that a lodger is technically a licensee. A licensee is somebody who doesn't, by definition, doesn't have rights of occupation, and they're excluded from the Protection from Eviction Act, which means they can be evicted without a court order. Now that raises a couple of grey areas. Grey area number one is, are they really a licensee, or are they a tenant who the landlord is claiming as a licensee, and they've got full rights? And this came up in a landmark housing case called Street and Mountford, where the landlord described the arrangement as a license, but it was actually a tenancy. And the test is whether you have exclusive occupation of part of the property, or whether you of the property, or whether you share it. So if you had a room in a house, and the landlord lived there too, you could still be a tenant if you had your own kitchen and ensuite toilet, because it would be a self-contained unit. I think this is what happened in Street and Mountford, and it's happened in other cases. Whereas if you just have a room, as a lodger suggests, and you make your food in the communal in the main kitchen, and the bathroom and toilet and everything is shared, then you've got no rights of occupation. Having said that, your landlord isn't, or the person you're staying with isn't entitled to physically throw you out, because that's a criminal offence, that's assault, if they sort of picked you up. But by the time the police arrive, that may all be over and you're just trying to get back in. And I still don't, I'll find out why the police were so on this lodger's side, but usually the police would just say, no, go to the council. And they should have done that in this case. They should have taken the lodger down to the council, because it sounds like he had priority need, but they just didn't want to deal with it. So if you're a lodger and you're facing eviction, you're probably not going to be able to go to court. But obviously, if somebody's threatening to throw you out and you're in your room, you could call the police and say, I'm worried I'm about to be assaulted. So that's my talk on that. I'll say some more about it next time when I've looked into it a bit further, but I don't know if anybody wants to comment on that or not.
Sorry. I would ask about are they still required to give notice to a lodger though?
Well, this is if you look on the CAB website and the shelter website, it's very ambiguous, because they say you should give reasonable notice. And this is a good example of why reasonable is a lawyer's favourite word. because it doesn't mean anything, and lawyers can spend all day getting paid for arguing about it. So the CAB website, which I next time I do this, I'm going to sort it so everyone can see my page when I'm looking at this. So I'm not going to fiddle about while I'm doing this. But it says the question they ask on the website is, how much notice should your landlord give you? And the answer is, the amount of notice your landlord must give you to move out usually depends on whether you share living space with your landlord, or whether your landlord can enter your room without telling you first. But it doesn't go on to say that you should get reasonable. I think the shelter website talks about reasonable, but I think that CAB advice is a little bit misleading, because if you share living space with your landlord, that's the definition of being a lodger. Whereas if you don't, and you've got exclusive occupation of your living space so that you can go all day without seeing the landlord, and you could lock your landlord out and carry on, then you're probably a tenant. And it's a worry for people like the person who contacted me, because the danger is they could get taken to court, and it could take a year or something of legal proceedings until they find out they're okay. And there was a case, if anyone's interested, called Gibson v Douglas in 2016, where it went all the way to the Court of Appeal, and it was held that the lodger didn't have a right to stay there. I'll tell you some more about that next time. But the shelter website, if I go back to that, so I think the CAB's basically saying if your landlord, I mean, a lodger could, I mean, basically if you've got a lodger, you could enter the room without permission, because you could say, well, I'm just doing the hoovering or something, and they're a guest in your house. Well, not a guest, but they might be paying. But you know what I mean? It's more understandable. But I think that would mean, but if you've got exclusive occupation, you're not a lodger. And then the shelter website says, they talk about a lodger agreement. A lot of people won't have a written agreement, because the one answer to your question, Karis, is it depends what the notice period in the agreement is. But I would say probably 80% of lodgers don't have a written agreement. Wouldn't you agree?
Yeah.
It's usually an informal arrangement. The question on the shelter website is, what is reasonable notice? It says your landlord needs to give you reasonable notice if your agreement doesn't mention a notice period. And then it says what is reasonable. And it says reasonable notice must be fair to both you and your landlord. 1 month is reasonable in lots of situations. Sometimes it could be more, for example, if you've lived there a long time, but it could be less. For example, if you and the landlord find it hard to live together. And I think in the case of Gibson v Douglas, I mean, we're talking the notice period was in minutes or hours rather than anything longer. But I don't think, there's two problems with this, is that shelter can't really say, and I'm not criticising them, I can't do it either, where you pin the tail on the donkey here. Because if you haven't got a written agreement, and even if you have got a written agreement, it isn't necessarily legally enforceable, and it wouldn't give rise to, well, it might give rise to a defence, but you haven't got security of tenure, so it's likely if you went to court, the judge would say, well, I'm not going to make an order because you're excluded. But I would say it would be pretty rare that you could enforce it. And again, if it's not written down, then I mean, the judge would say, well, it's not for me to decide what's reasonable. And again, by the time you got in front of a judge, it would have been 5 times as long as it was probably since you got evicted. So the danger for lodgers, I think, is that you could easily go out, come home, find the locks changed, and there's absolutely nothing you can do about it, really, other than go to the council and try and get rehoused. Which is why you should, if you're having trouble as a lodger, you should, and you think you might be in, well, I mean, it's still worth it even if you're pretty sure you're not in priority need, because the council could still help you under the prevention duty or the relief duty. So you should get in touch with the council as soon as you can, because the danger is, once you're out, unless you're very lucky. I mean, I've never heard of the police actually before. I've never heard of the police go around and saying you've got to let this person back in, but that may be because I should get out more. But that's my sort of sermon on lodgers for today. I'll just
Can I
see if
just
I
ask
can-
one more question?
Yeah, please.
When you move into a property, you put a deposit down. So what's the difference when it's a tenant and a lodger for the rent deposit and the protection scheme?
Oh yeah, well that is that if obviously that's a really important question because the payment of a deposit to a landlord where you're a tenant, and this is still in effect because you basically the default position is if you are a tenant, you're an assured short-hold tenant, and therefore a deposit has to be protected. And if the deposit isn't protected, then you have a complete defence to a possession claim later on because you can't serve a valid Section 21 notice. Plus, you can claim compensation, the return of the deposit, plus multiples of it. But obviously, if you give a deposit, it'd be pretty. I mean, if you were a lodger and you gave a deposit, then you're stuck because you sit it out. I think that would just simply be a contractual thing that you would say, I paid this money. I didn't do any damage, and I didn't owe him any money at the end, so I should have my money back. And you'd be this is what the situation was before they introduced the tenancy deposit protection, because landlords would take deposits off assured short-hold tenants, and they'd never, you're supposed to hold a deposit, but they never would. They'd have spent it sort of straight away. And then when the tenant moved out, and I had a case like this, the landlord will obviously allege that they had to fumigate the place and rebuild the walls and everything, and you can't get in there, so you can't prove it, and they can get their mate who's a builder to come down and say, here's the invoice I issued, and that's the end of that. So that's why it's got to be protected, because the courts were aware that people were getting ripped off and they couldn't do anything. But if you're a lodger, you're still in the same position as before, because you wouldn't have the remedy of being able to have a defence to a possession claim, because there wouldn't be a possession claim, and you wouldn't therefore be able to get the full compensation. So, hang on, I've got a couple more. Have I got? I think, no, sorry, these are the old comments. So I think if everybody's okay, I think that's probably it for tonight. And again, I hope that people watching this I hope that I can look back, if I do, watch some of the earlier live streams, and that the quality of this is getting better in terms of presentation. But as I say, next time I'll try and get screens so that we can actually look at things together. Like when I refer to the shelter website, I'll show it, and the same with the local government stuff. But that'll hopefully be next week. But hopefully we'll be all on for Thursday. So all over at Mike's place on Thursday then.
I can't on Thursday.
Oh,
sorry.
no.
But I'll be travelling back from Leeds. Sorry. But I'll be here Monday.
Excellent. Okay, so I look forward to seeing you then. And thanks everybody for coming in and helping out and with this one and watching, and those of you watching and making comments. And I should say, if you like the show, please hit the like button and subscribe. I'm hoping to get up to 100 followers soon. So and then hopefully build on that. I think I'm at 89 at the moment. So anyone who wants to subscribe, please do so. And see you all see you Mike and Cara, see you Thursday, Shannon, see you Monday. Bye for now.